So, I give this one a 5.
Oh.
Hi, everybody. Welcome to Oregon Law Lab. Today we're talking about the biggest settlement fails. We have a very special guest, Michael Moffitt. Michael read a lot of cases about really bad lawyering.
Yeah, I read 24,000
You
cases.
read 24,000? You read all of them?
I skimmed a lot of them.
Why didn't people write about this before?
I never really studied negotiations that went badly.
That's true.
And then when I started looking, I found like a lot of negotiations that went very badly. I mean, I was just fascinated by all of these absolute train wrecks. I never even imagined in my least competent moments doing some of these things.
In your least competent moment. Okay, so you're going to tell us about the worst ones.
Sure, yeah.
And then we'll rate them on a scale of like, let's rate them on a scale of like, kind of understandable to like call their mother.
This was a disciplinary proceeding against him. He did, there were 75 counts against him.
From one client?
No, there were 10 different clients.
There were 10 clients.
This was what the Illinois Supreme Court called a pervasive pattern of misconduct. No. I know. One of the things that Mr. Lamb did, he got a settlement offer and he accepted it, signed the back of the check for deposit only to himself, deposited the check to himself, told the client, yeah, it looks like it might settle, it's still in the works, we have some paperwork to get through. And like years go by and the client periodically says like, hey, what's the status? And Mr. Lamb says like, paperwork, it just takes a while.
He stole the money. He signed the settlement, took the money, and then he told the client, we're still working on it.
We're still working on it.
That's like a bad scam because there's no like exit strategy. So what rating do you give this one?
This is terrible. So it's got multiple bad pieces, right? It's got there was an offer that you never told your client about.
Okay, that's bad. That's pretty bad.
Accepting an offer without your client's permission.
Okay,
also super bad.
Okay.
And it's self-dealing.
I'm gonna give it a 7.5.
Fine.
Because it was not like competent bad.
So there was this guy. He was a longshoreman. Worked on a boat. He got injured on the boat. Like badly injured. Okay. Filed a claim. His lawyer gets an offer from the other side to settle for $90,000. His lawyer said to the other side, go to hell.
Okay.
Never told the client. The lawyer makes two arguments in this malpractice case. One is, it was just a terrible offer. It was so bad I didn't have to tell you about it. Okay.
Which, you said it was a bad offer, so...
I mean... There's no theory where it could be bad enough that you shouldn't at least tell you. Like, I'll offer you a nickel. I'll offer you a peppercorn. You didn't tell me about the offer. I get to make the choice between a lousy offer and going to trial.
You know what I think it was? I think this guy was like a know-it-all lawyer.
Could be.
One of those guys was like, I know what's best for you. Yeah, I'm going to decide.
Totally are
But he wasn't that good because he lost.
He lost. So this goes up to the First Circuit. And then Judge Breyer, I think, is on the panel that agrees with the lawyer here.
Well, so he was better at defending his malpractice case than he was at litigating his case. His priorities were a bit off.
I think that may be right. Anyway, maddening case.
So you're upset with the court. Don't let that interfere with your rating.
This is like a 6 out of 10 bad.
Really? Because I want to give it an 8 because this guy's arrogant, and the other guy was just criminal.
There was an injury at a Walmart, and it wasn't like a slip and fall.
What kind of Walmart injury?
Like a bunch of stuff fell on a shopper, like big heavy boxes.
Oh no, that's not good.
It's bad.
Not good.
It was really bad. And Walmart makes an offer. They say to the lawyer, the clients aren't there. They say to the lawyer, "We'll give you $35,000 to settle this thing," and the lawyer says, "Great, we'll go with that."
So the lawyer takes the settlement.
So it's
the opposite of the other one.
He's like,
you got it.
We got your settlement.
$35,000.
The client's like, no. And the lawyer's like, goes back to Walmart and basically says, yeah, what I meant by yes was no. But of course you can't unring the bell, right? Walmart will never unhear the yes.
I think this guy was a bit overeager, which is not as bad as criminal or arrogant. So I give this one a 5.
Oh. There was a headmaster of a private school, and he gets fired. He says it's for age discrimination reasons or retaliation reasons, and they reach a settlement. A settlement contains a clause that has a confidentiality provision, and the confidentiality provision is breathtakingly broad. It
Which
says,
a lot of them are.
A lot of them are. This one
are.
says that the parties shall not disclose directly or indirectly, not just the terms of the settlement, but the fact of the settlement, like anything having to do with the settlement whatsoever. Right? So they sign this, and 3 days later, the teenage daughter or college-age daughter of the headmaster posts on Facebook a message saying, Mom and Dad won their lawsuit, so I'm going to Europe on their dime. They can suck it. Right? Yes. And the school catches wind of this Facebook post, and so they refuse to comply with their part of the agreement, and they stop payment on some of the payments. And the court says, yeah, you breached confidentiality.
I actually came across this case when I was looking up, confidentiality cases pre-Me Too.
Yeah.
Right, this was not common. We're going to unravel the entire settlement because one person disclosed the facts underlying the case.
The reason this is malpractice is any competent lawyer should take 15 seconds and say to the parents, okay, so what does this mean in terms of what you're going to tell?
He's headmaster. He can read.
Is it a 5 out of 10? For sure.
No!
Oh,
this is a 0 out of 10.
No! The defendant was accused of assault with intent to murder. A plea offer was made.
Okay.
And the defense counsel went to the accused. Bad deal. We shouldn't take this because although you shot her multiple times, you only shot her below the waist. So that can't be with intent to murder.
Look, I'm not a criminal lawyer.
Right.
But to me, the bar exam does not include a question of recognizable defenses to attempted murder. Just shooting them
only below the
waist.
Right.
Once you're firing multiple shots, maybe you are intending to kill the person, or maybe just one shot, regardless of where it goes. Unless you're a sniper. And you just shot them in the kneecap.
You're basically misinforming them about what their likelihood, their likely prospects at trial are.
And then the guy went to jail.
Oh, totally, yeah.
For a long
the
time.
jury was,
The jury was we think
you
that shooting someone many times
right.
means you intend to murder them. Okay, what do you give this one?
I give this a 7.
I give this one an 11.
11? No!
Because they went to jail!
Oh.
All the other things were you're out $35,000 or whatever. And this one's you're in jail.
We're focusing on the lawyering.
My analysis is not legal. This is just every day, they went to jail.
The courts totally agree with you in the sense that it is easier to find that a lawyer has committed constitutionally inadequate representation.
Mm-hmm.
They are constitutionally inadequate. That bar is easier to get over than they committed civil malpractice.
Oh, totally. That makes sense to me.
Totally crazy.
No. Because judges just don't like having their time wasted. All those judges, they have to sit there. They can't move. Have bed sores from sitting in the chair.
You and I have much better jobs than these judges do.
So they're this guy went to jail. He's that serious.
Our nation's founding document can find you deficient, but the client still owes you their fees because you're not committing legal malpractice. How can that not be lawyers just protecting themselves?
Note to self: be a civil lawyer.
Be a civil lawyer. That is.
You want to be really bad at your job.
Tell your client about offers you get. Tell them the implications of settlement offers. Tell them what going to trial might look like. Let them make the choice. It's not that hard.